The state of our environment and the condition of the world in which we live and work mirror our attitudes and our behaviors. It goes without saying, we will not have a society if we destroy our environment. Every single one of us has a right to clean air and pure water. The preservation of the natural, scenic and aesthetic values of the environment forms part of that right. Within recent years, there's been an upsurge in international and global awareness of the factors affecting the world's environment. Countries have been rapidly amending or adding legislative and other measures in a bid to enhance environmental management. Here in Trinidad and Tobago, government has taken several initiatives to protect our land. Some of their efforts include becoming signatory to a number of international conventions and treaties and gaining access to the various environmental instruments. The latest initiative, however, has been quite significant, and we're talking here about the establishment of the Environmental Commission of Trinidad and Tobago.
The Environmental Commission of Trinidad and Tobago was established by the Environmental Management Act 2000. The Act established the Commission as a superior court of record with a seal which is supposed to be judicially recognized. The Act gives the Commission its jurisdiction and powers, and it also has all the powers inherent in a High Court of Justice. The Commission is comprised of a chairman, a deputy chairman, and 4 commissioners. The chairman and deputy chairman are attorneys at law and appointed by His Excellency the President of Trinidad and Tobago.
Under this legislation, the Commission has been given the authority and jurisdiction to hear and determine certain types of matters.
These include appeals from decisions or actions of the Environmental Management Authority. You may well ask whether or not a private citizen has an audience before the Commission. Yes. Under the legislation, what we call a direct private party action can be brought to the Commission by members of the public. However, these matters can only be brought where there is a violation of an environmental requirement. The Commission, apart from having the jurisdiction to hear and determine matters in open court, under the legislation, we can also resolve issues by the use of alternative dispute resolution. The process which has been identified by the Commission as the most useful alternative dispute resolution process is that of mediation.
Why mediate? Mediation is more cost-effective and more time-effective than other methods of resolving disputes. It is of paramount importance that the parties are comfortable during the mediation exercise, and that is why we have opted to utilize the conference room. It provides a venue for dialogue rather than for any sort of adversarial approach. While the Environmental Commission is quite young, our experience here has been that mediation is very effective. In fact, all matters that have been mediated upon at the Environmental Commission have been resolved satisfactorily.
All cases for trial are heard in open court, and any member of the public has a right to attend. In addition to the chairman and deputy chairman, there are at present 3 other commissioners also appointed by the President. Besides having extensive knowledge in environmental health issues, environmental sciences and industrial chemical issues, these commissioners are trained in mediation.
As a member of the Environmental Commission, my role involves giving of technical advice and expertise and interpretation on matters that require scientific input in the field of natural sciences, the specialty area being that of chemistry and chemical compounds. I am able to assess certain of the scientific and technical issues that may surround very complex environmental matters brought before the court, and which, as you would well appreciate, requires a multidisciplinary team approach.
When matters of an environmental nature come to the Environmental Commission, in terms of, for example, an environmental impact assessment or an EIA as we know it, This is the point at which my expertise is important to the Commission. It is here that I will have to, as the environmental scientist, evaluate, assess, and weigh all the consequences or impacts on the environment and assist the Commission in coming to a decision. In this assessment, one has to remember that it's not only the environment in terms of water, air quality, sea and the marine or coastal environments, but it's also the quality of life and how it affects people and their ability to earn a livelihood.